In the span of just 25 years, the digital world in India has completely, fundamentally transformed. Decades ago, the law viewed internet platforms basically as passive digital pipelines, just simple, dumb tubes carrying data from point A to point B. But today they are heavily regulated, algorithmic gatekeepers acting practically as AI cops. We're going to dive right into this explainer and look at the story of how that incredible shift from absolute legal immunity to strict, demanding accountability actually happened.
So here is our roadmap for today. First, we'll look at the era of passive pipelines, then enter conditional safe harbor, followed by the rise of accountability. After that, we'll get into regulating AI and deepfakes, and finally wrap up with current platform tensions. This whole structural progression really reveals a permanent, massive shift in the country's techno-legal architecture. Section 1. The era of passive pipelines. Let's rewind the clock all the way back to the year 2000. The Information Technology Act had just come into force, and the internet in India was, it was in its absolute infancy. At that time, the IT Act defined an intermediary as entities that merely received, stored, or transmitted electronic records. We're talking about your classic internet service providers, web hosting companies, and local cyber cafes. Under the original Section 79, the law viewed these entities largely as technical conduits rather than active participants in online communication. Because of this, they enjoyed absolute immunity for any third-party content flowing through their networks. As long as they functioned purely as passive pipelines without modifying the data, they were completely off the hook. But there was a major catch. If an offense actually occurred, the burden was entirely on the intermediary to prove that it happened without their knowledge or despite their due diligence. Basically, they were forced to prove a negative just to escape liability.
Section 2. Enter conditional safe harbor.
So, as the internet grew, that original 2000 framework really started to show its cracks. By the mid-2000s, the digital landscape was becoming a lot more complex. High-profile litigations, like the famous Avnish Bajaj versus State case, proved that the old laws just couldn't keep up with reality anymore. Systemic gaps were essentially forcing the law to evolve. Prompted by those early legal battles, the government totally overhauled Section 79 in 2008. And this represented a profound philosophical shift. We moved from absolute immunity in 2000 straight to conditional immunity in 2008. The old philosophy was essentially, you are liable unless proved innocent. But the new 2008 philosophy? That changed to, you are immune unless statutory conditions are violated. Suddenly, platforms were granted the safe harbor, but only if they exercised due diligence, didn't initiate the transmission, didn't select the receiver, and, crucially, complied with government directions to remove unlawful content once they had actual knowledge of it. Following that 2008 amendment, 2011 brought India's first comprehensive due diligence rules. For the very first time, platforms were required to publish terms of use, appoint grievance officers, and outright prohibit specific categories of unlawful content, things like obscenity, copyright infringement, and hate speech. But this actually led to a massive problem. Anyone could flag content, and platforms, naturally fearing liability, might just take it down to be safe. It was a chilling effect. So in 2015, the Supreme Court stepped in with the landmark Shreya Singhal case. The court fundamentally reinterpreted what actual knowledge actually meant. They ruled that an intermediary only had to take down content upon receiving a specific court order or a direct government directive. This was huge. It protected private citizens from arbitrary takedowns by forcing platforms to act only on official state or judicial orders. Section 3. The rise of accountability.
The balance struck by that Shreya Singhal case held for a while, but as social media completely exploded in influence, a new era began. In 2021, the government replaced those 2011 guidelines with a massive new framework aimed at increasing transparency and user protection. This marked the definitive end of simple safe harbor, transitioning us into safe harbor with strict accountability. The 2021 rules introduced a tiered system based on the size and function of the platform. While standard intermediaries had your basic rules, significant social media intermediaries, basically the major platforms, faced incredibly heavy burdens. They were suddenly mandated to appoint India resident compliance and grievance officers, file monthly compliance reports, and critically deploy systems to trace the first originator of automated or encrypted messages. Intermediaries were absolutely no longer just passive conduits. They had heavy, active compliance obligations. And by 2023, the definition was expanded even further to include online gaming platforms, which came with their own highly specialized obligations.
But you might be wondering, how do you ensure the government doesn't just abuse its power to order all these content takedowns? Well, that brings us to the 2025 amendments. These rules reformed the actual knowledge pipeline we talked about earlier. To ensure takedown decisions were transparent and proportionate, the law mandated strict executive safeguards. Takedown orders now have to be structured, written, and reasoned. They must be issued by senior personnel, nobody below a joint secretary rank. And to ensure proper oversight, they're subjected to a mandatory monthly review by an officer at the secretary level. It's a highly formalized, state-backed mechanism specifically designed to keep the whole process accountable.
Section 4. Regulating AI and deepfakes. Technology is moving faster than ever, right? And the proposed 2026 amendments are designed to tackle the massive, unprecedented dangers of synthetically generated information, what you and I commonly call deepfakes. Intermediaries will be legally required to follow exact, strict operational steps to handle synthetic content. First, they have to identify it. Second, they must embed non-removable metadata to preserve the provenance of the media. And third, they must display persistent labels noticing that the video is synthetically generated. And they have to do this throughout the entire duration of the visual display. So the really crucial point here is that intermediaries are no longer just policing user-generated content. They are now actively expected to police AI-generated content. They're evolving into active participants in AI governance.
2. Under these new synthetic media rules, platforms have just 2 hours to remove non-consensual intimate imagery once it's reported. 2 hours. And they have only 3 hours to remove other prohibited synthetic data. To put that into perspective, in the past, turnaround windows for grievance resolutions were around 72 hours. This massive, literal compression of compliance timelines shows exactly how urgent and high-risk synthetic media is viewed by lawmakers today.
Section 5. Current platform tensions. All of these mounting regulations lead directly into the current clashes we're seeing between government regulation and platform technology today. This constant erosion of safe harbor certainty, we're missing a 2-hour window could cost a multi-billion-dollar platform its legal immunity, has real-world consequences. For example, there is a major ongoing tension right now between the government of India and WhatsApp. WhatsApp wants to allow users to pick a custom username, kind of like a domain name, instead of publicly displaying their phone number. From the platform stance, this protects user privacy. Furthermore, WhatsApp argues that identifying the first originator of a message is technically impossible due to their end-to-end encryption. But on the flip side, the government's stance is that hiding phone numbers behind usernames hurts the identification of users, allows for impersonation, and completely breaks the 2021 traceability guidelines that law enforcement needs to track unlawful content. It's a direct, fascinating collision between a platform's technological design and a nation's legal mandates. In a pretty stark example of exactly what's at stake here, Instagram recently faced intense scrutiny over automated ads that contained abhorrent, exploitative material targeting children. Now, while Meta stated they removed this deeply harmful content, the whole controversy highlights incredibly complex questions about what exact level of due diligence is truly expected of these platforms, especially regarding the role of AI in generating and then slipping these abusive ads right past automated content detection filters. It begs the question, when the law says platforms absolutely must deploy algorithmic tools to police media, what happens when those tools just fail? So, what does this all mean for us? As we've seen, Safe Harbor is no longer a static, absolute shield. It is a highly active, incredibly demanding compliance standard. In effect, the intermediary has evolved from a simple, passive carrier of information into a co-regulator of the entire digital ecosystem. But it leaves us wondering, will these stringent intermediary guidelines face continued constitutional challenges from platforms and privacy advocates? Or is this highly regulated, 2-hour takedown AI policing role simply the permanent reality of our modern digital ecosystem? It's a 25-year legal tug of war, and frankly, it is still unfolding right now.